Hello, everybody, and welcome on today's webinar on hot topics in advertising law in Europe. My name is Dusan Nitschneider. I'm the moderator and the speaker of today's webinar. The webinar is organized by GALA, which stands for Global Advertising Lawyers Association, joining the advertising, media, and IP lawyers from all over the world. Let me introduce to you today's speakers, who are Baran Güney from Günen Partners, Turkey, Ignacio Temino from Abril Abogados from Spain, then Fleur Chenevix-Trench from Silkin, United Kingdom, and last but not least, Conor Griffin from Duncan, Grehan and Partners, Ireland. Before we start, one technical issue. On your right-hand side, on the bottom part of your screen, you can see the Q&A button through which you can pose the questions during the webinar. I'll be watching them and will, let's say, interrupt each of the speakers to whom the question will be addressed, and will answer him the question instead of you. So that's basically everything from the technical part. I'm switching now to Baran, who will introduce us the latest news from Turkey. Baran, the floor is yours.
Thank you, Dusan. Hello, everyone. My name is Baran. I am working as Managing Associate at Günen Partners. It is indeed great to be here with you. Thank you for participating. Recently, there are full of hot topics in terms of advertising law in Turkey. I'm really excited to share with you some examples. Let's start with green claims. Because green claims are expanding, the Advertising Board in Turkey recently issued a guideline on environmental marketing claims. This guideline contains very detailed rules and examples which are very instructive. The guideline sets high standards for substantiation of the environmental marketing claims. Basically, any environmental claim must be substantiated by concrete facts and scientific studies. The guideline contains very specific rules for this, but I will not mention here. I will just briefly explain you. It is possible to use all green claims listed here and even more, as long as they are sufficiently proven. There is no restricted list of green claims as long as these claims are true. It is principally the green claims should not cause any confusion before the consumers. They should be clear which part of the products or services that the green claims relate to. If the advertising itself is not sufficient to convey all detailed information, it might be possible, of course. It is then possible to direct the consumers to a website where the detailed information can be found. I have some examples for you about the green claims and showing high standards of advertising board. Martı, for example, in this decision, in this ad, Martı is a scooter rental app. The advertising board found misleading the claim suggesting that Martı has saved carbon dioxide emission equal to 250,000 trees as of today, because the company couldn't substantiate this claim at all based on sufficient evidence and with a verifiable strategy plan. In another decision, Vodafone's claim suggesting Turkey's one and only service provider that uses 100% renewable energy was found to be misleading because it creates the impression as if Vodafone was the only green-friendly company in the market. But the board easily found out that there are other telecommunication companies generated all of its electricity consumption through renewable energy. In another example about aspirational claims, I can note that they are permissible only if such claims are included in a strategy plan that is publicly available and verifiable. So, advertising boards in advertising board's decision, recent decision about an airline company's claim suggesting that we reduce our carbon emission 20% by 2030 was found to be lawful this time because the company had a publicly open and verifiable green strategy plan to prove this fact. Another hot topic in Turkey recently is AI-generated ads. This must be the case for all EMEA region. First of all, we have no specific rules for AI-generated ads. The advertising board investigates these ads based on general principles of advertising law, which are the truth and substantiation of claims. The advertising board imposes sanctions to the superiority claims, mainly to the superiority claims created based on ChatGPT data. Because the data of the ChatGPT might not be scientific, it is not scientific actually. And even when the advertising board asks ChatGPT to confirm the answers by asking, for example, are you sure? ChatGPT, it is shown that ChatGPT answered that the data might be either old or it should be confirmed through other ways. So ChatGPT itself also confesses about uncertainty of the data it provides in terms of superiority claims and ads generated through ChatGPT. For example, in this ad, the claim was, according to ChatGPT, Elsivayki, this is a textile company, by the way, Elsivayki is Turkey's largest fashion retail brand. Advertising board found this ad misleading, found this claim misleading, because when the board even asked ChatGPT, are you sure? ChatGPT answered that, I apologize, my latest data is until 2021. So the ChatGPT responded that it is not sure and the data might not be updated. In another example, in this ad, the claim was, we asked ChatGPT and got the only correct answer to conduct fast, secure, and cost-effective logistics transactions to any location in the world. Meet Navlungo now. Again, the advertising board found this ad misleading because when they asked ChatGPT the same question, are you sure? ChatGPT said that there are many companies providing such services and the market is constantly changing. It is therefore difficult to name a specific company. Please check the websites to find the most suitable company. This again shows the claim in the ad was uncertain. In another ad about the media company, Channel D, the claim was, according to ChatGPT, Channel D is the most iconic private TV channel in Turkey. When the board asked, are you sure? Again, ChatGPT, it was answered that there can be many different views regarding the most iconic private TV channel among channels in Turkey. So the answers were not certain. The board found this ad misleading. Another topic that I would like to mention in this webinar is dark patterns, which has recently entered the agenda of the advertising board. Again, there is no direct definition for dark patterns under Turkish law. It is mainly evaluated within the scope of unfair commercial practices, which is ruled in the advertising regulation. Using manipulative tools, website designs, options that might manipulatively direct consumers to conduct a purchase of a goods or service might be considered as dark pattern and also unfair commercial practice in Turkey. In its recent decisions, the advertising board imposed sanctions based on dark patterns rules for presenting pre-selected options to consumers or making alternative, cheaper subscription options difficult to choose. For example, in this decision, Turkcell is a telecommunication company, a reliable one in Turkey, by the way. It offers customers an easier path for annual subscription, but instead it offers customers a more difficult path for monthly subscription. When you click on the monthly subscription button, it directs you to the detailed rules and information. But when you click on the annual subscription, it directly proceeds to checkout to buy the service or good. So advertisement board had this commercial practice as dark pattern because the company provides an easier path for annual subscription method in comparison to monthly subscription method. In this decision, offering various subscription options to consumers, but pre-selecting the model that is the longest in term and the most favorable to the provider was considered as a dark pattern by the advertising board. In this decision, Microsoft designing tools for making purchase of an updated version of the product offered by the provider itself in a more attention-grabbing manner, while designing the tools for keeping the older version of the product software in an indistinguishable manner was considered as dark pattern again. That's it for me. Thank you.
Yeah,
I hope you
thank
enjoyed.
you. Thank you. Sorry for interrupting you at the end, but thank you for your explanation or introducing what's new in Turkey. Let me now for a moment speak what's new in Slovak Republic. We have so far no AI, as Baran was introducing. What we have new, or what we have as a hot things in our advertising legislation, is that our parliament has adopted new Consumer Protection Act and the new Act on Representative Actions, which is the class actions in general. And we have a couple of, let's say, new situations with influencers and influencer regulation, which I will speak at the end of my presentation, or my part of presentation. Regarding the new legislation, we have new Consumer Protection Act. It's not just out of the blue. It's the result of the transposition of EU Omnibus Directive. We already had the Consumer Protection Act in place, but the new one completely replaced the old one. Basically, the new one strengthens the position of the customer, and it's mainly concentrated on the e-shops or the virtual part of consumer protection. Regarding the it brings up new measures for or to avoid price manipulation, and it gives new rules for the vendors, for the sellers to show the price. They, together with the current price, they also have to list or show at the same spot or the visible spot what was the lowest price they were offering the product for the last 30 days. That should probably, or this is understood as the prevention for blowing up the prices before the big sale events like Black Fridays or Christmas sales, to blow them up and then show dramatical big discounts, but at the end the seller will receive the same amount of money as he was selling the product for the majority of the year. So that is something which is, or which sounds promising. Second important things is, let's say, the group of rules for the vendors regarding the reviews. They should take all appropriate measures to make sure that the reviews that they publish on their websites are made by the real buyers of the product, which, of course, it's aimed to prevent or to avoid or to put away the reviews which are written by either robots or which are written by people who are somehow paid for writing positive reviews. Last but not that important thing is that it's raising the penalties. They are now, or at the moment, they are set by the real amount. The new setup will be based on the annual turnover, and the maximum penalty will be either 7% of the turnover or 200,000 euro. On the bottom of the slide, if you can read it, or I hope you can read it, you can see, let's say, the print screen of one of the e-shops showing, let's say, the women's jacket, showing the current price, showing the original price, which is on the right side, and in the middle, which is bar crossed, it's the lowest price within last 30 days, which is exactly the same as the price which is offered right now. So that's already happening, even to the fact that the new Consumer Protection Act, it's already passed by the parliament. It was passed in April, but it will become effective only on the 1st of July. So some of the vendors are already prepared for that because the parliament has been discussing this act for almost a year. It has been first adopted in August 2023, but it has been vetoed by the president. Then it stayed in the parliament for quite a long time, and as I said, it was adopted in April this year. Second thing, this might sound for many of you as pretty normal thing, but it's a big thing here in Slovakia. We have a new act on representative actions for the protection of collective interest of consumers. That's the full name. This is the first time we have something like a class action in our legal environment. So far, we only knew the individual actions, no class actions. So this is something which is quite new. It gives pretty unstandard scenario how a class action may be filed. It could not be filed by one or group of consumers. It should be filed by the organization that is protecting customer interests. There are various of them. They should need to get registered by the Ministry of Trade, but this seems to be quite just a very easy administrative thing. Before the action is filed, they need to publish so-called like incentive to file it within the commercial journal, which is the official journal which is run or organized by the government. And they have to get at least 20 customers within 2 months from publishing that interest. If they get 20 customers within those 2 months, then they can file the class action. Of course, all the other, it's not regulated and it's not an additional requirement. Of course, other customers, unhappy customers, can join the class action after it has been filed until, let's say, the verdict is delivered. But 20 is the minimum, and the 20 should join this activity or this incentive before it has been filed. So this was questioned also by the president. The president also vetoed this part because she thought that it's, let's say, it stops it's some kind of burden for the effective protection of the customer's interest. But anyway, Parliament overruled the veto, and it is as it is. We know that some of our neighboring countries don't have this formality, but that they need at least 20 unhappy customers joining that, but not in the initial phase, but during the whole procedure. So this is, in a nutshell, the basic principle of the collective or the class actions, sorry. And now let me discuss, or let's say, discuss and brainstorm with you about the influencers and politics. We had general elections in September last year, and we had presidential elections in March this year. The public opinion, or the public in general, is very much divided. There is a quite high tensions among the public. People are debating politics everywhere and every time. Let's say all these, there are still feelings because we are also expecting the Euro elections in June this year. So there is a lot of discussion and lots of pressure and lots of emotions, let's say, all among the society. And during the recent presidential elections, there has been, as a consequence of, let's say, the highly tensioned campaign, there has been some consequences which were, let's say, which took part or which related to the influencers. As the two candidates going to the second round were trying to attract more and more people, they were trying to use as many influencers, public personas, or celebrities. On the picture, you can see one of, let's call it celebrity. It's Mr. Attila Veg. He's an MMA fighter. He's pretty successful MMA fighter, very good MMA fighter. And he, during the last 48 hours before the second round of elections, where all the political advertisements are forbidden, he broke the rule and he posted on his Instagram a post that supported one of the candidates just during these 48 hours of ban. And after the elections, or let's say within a week after the second round of elections, the Renault, which was a brand that was using him as the influencer, they canceled the cooperation with him, stating that he became, or they do not wish to be part of the political fight. But the trick was that they had no written contract. They had just think that, okay, Attila Weg, he will be somehow representing the Renault, and he will be, I don't know, he was given one car and he was using the car and he was publicly showing that he's using Renault car. And which is like, okay, influencers are, or influencer marketing is quite, or is running all around the world for quite some time. We also have some, let's say, influencers marketing codes of ethics, etc., etc. But we still consider this as something which is quite new, and usually there are no written contracts between the brand owners or advertising agencies and the influencers, which would specify the rules for the influencer, what he should or he should not do, like be part of the political fight, or the conditions for termination the contract. So let's say it was quite a huge debate on the marketing market, like why Renault, or did Renault specify enough to Attila before the presidential election that they do not wish to be part of the political fight, or did they not, or did they terminate a contract correctly, or does Attila Weg does he have some rights to sue them? Let's say it all ended up by, let's say, not a mutual agreement, but there was no other, let's say, court dispute for that. But the recommendation is that, okay, you can use the influencers as much as you can. They have, or you have, and they have the group of rules in the influencers marketing codes. But please do not forget to properly contract them and set up the conditions that you as the brand owner like them to fulfill. That is basically all what is hot on the marketing market in Slovakia. And I'm now passing to Ignacio to let him explain how things are going in Spain.
Hello, everyone. Thank you very much, Dusan. Good afternoon, all participants. It has been difficult to select the number of topics to discuss on hot topics because there are many issues going on, as probably in the rest of European countries. But I have made a selection, and just to give an idea of which is the status where some important topics are at this moment in Spain, and the most recent news that we have coming into the Spanish market. First of all, I would like to introduce you to one of the most controversial ministries that we have had the last years in Spain, who is Mr. Garzón. He was the Minister of Consumption, protecting consumers. And he has made a number of new regulations and initiative for new legislations, creating a lot of problems within the industry, the enterprises, and the consumers as well. For example, one day he said that all Spaniards should be eating less meat, and of course all the meat manufacturers and producers were on strike against him because he was talking plain without any kind of disclaimer or support or whatever. So one of the initiatives that he took during the pandemic time was to restrict very strictly the advertising on gambling activities and all sort of baits and similar money games, online, not online, etc. This was, according to his opinion, as a consequence of the increase of addiction to gambling during the pandemic time. That restriction has been now not completely cancelled, but partially cancelled by a recent ruling of the Spanish Supreme Court dated last April, which has cancelled due to lack of enough justification the most difficult and wide restrictions. For example, using celebrities to sponsor gambling ads, for example, doing digital advertising of gambling activities out of the websites of gambling services, for example, attracting new users for gambling websites that were not already users. So it's a kind of contradiction. How do you create new users if you can not if you have to go through the old users? And those restrictions have been considered by the Supreme Court as not sufficiently grounded. This was an appeal from the Association of Gambling Operators that were challenging the whole royal decree. And finally, the Supreme Court has attended and granted that petition, but only partially. For example, now it is also possible to place gambling ads on video platforms like YouTube or TikTok or similar social media platforms. During the last 4 years, we have not seen any advertising in any of those platforms. And all of us, we know that gambling operators are very strong advertisers. So it was in Spain, for example, they have been sponsoring football clubs, and they have been sponsoring music entertainment, concerts, live concerts, etc. So it was a very strong decision at the time. We will see that some of those past actions, commercial actions, will be back, but there are still many restrictions in force. For example, the timing. The timing of any advertising is limited to 4 hours at night between 1 and 5, which is really a narrow window. Secondly, all operators must be registered before the ministry and has to pay a very high registration fee to operate in Spain. There are many other restrictions about the kind of advertising that you can do, which are still in force. And the worst of this is that the window of freedom will be quite limited, because the same ministry has already announced a new legislation trying to replace, again, all the restrictions that have been cancelled, but now using a proper support. So we don't know for how long the gambling ads will be available in Spain, but probably it will be quite short. On top of that, we have had also some developments regarding influencers and vloggers, because the transposition of the directive regarding audiovisual services included also a provision considering some influencers and vloggers as audiovisual media operators. But we didn't know which were the requirements to be subject to those regulations, and they have been published this month of May, and they are 3 conditions that all of them have to be, or 4 in case the first one that can be interpreted. Those are the 4 conditions: 1 million or more followers in one video sharing social network, or 2 million in total, uploading at least 24 videos per year, and have an income of 300,000 euros or more. Well, there have been a number of negative opinions about this way of transposing the directive and of defining and creating the rules of audiovisual operators for influencers. Because what if you upload only 23 or 22 or 20 videos and not 24? It's a kind of quantitative restriction that should be easy to circumvent, to be honest. So we will see what is the development of this new regulation. And in the meantime, we notice also that the Spanish courts are quite active in in restricting the practices of influencers as media and in advertising. And the first appeal judgment from the Madrid Appeal Court has been published last month, which is the first one in the appeal stage, but will not be the last, because there are other number of cases open that will follow probably the same way. Most of them, as in the rest of the countries, are due to the lack of information regarding the relationship with the company who is sponsoring the influencer campaign. And finally, some news also regarding green claims, because it seems that Spain will be the first country transposing the Green Claims Directive, the one who has been passed on the 24th. We have already a draft going on, which is the Sustainable Consumption Act, which has been published a few weeks ago. And we have also, as you have in Turkey, a guide to interpret the Green Claims Directive, which in my opinion has not been properly drafted on time, because if we have a bill going on in the transposition, I don't understand why do we have already a guide, why we don't have any definitive transposition yet. But well, in any case, it's helpful to understand how the Spanish authorities will apply or are applying the directive while the national legislation is coming. And apparently it is quite strong. Don't forget that we are already living one of the strongest disputes on green claims in Europe at this moment between a fuel carbon company, which is Repsol, that maybe many of you know because they're sponsoring a lot of motor and bikes, and a company doing a lot of green energy, which is Iberdrola, which is one of the most important producers of electricity using renewable energy. Iberdrola sued for unfair competition Repsol at the beginning of this year, and this judicial dispute is ongoing in the market and has been quite follow in all newspapers. So it's bringing a lot of attention about the green claims, and therefore the government is also trying to be quite fast in transposing the directive. We will see if it will be a mistake or not, but in the meantime, this seems to be a race. We don't know the end yet, but this is all from Spain from now on. Thank you very much.
Ignacio, thank you again for describing things, new things in Spain. And let's now switch to Fleur, who will do the same for United Kingdom. Fleur, feel free to go.
Thank you. So the hot topic for the UK is the new Digital Markets Competition and Consumers Bill, which I should refer to as ACT, the DMCC Act, as it received royal assent last week, which is just in the nick of time given our the announcement of our general election. So these new laws have been described as a real watershed moment in protecting consumers, and there are quite a few changes which we'll talk about. So it'll come into force later this year, although saying that, some of the provisions around subscription practices won't actually bite until the spring of 2026. So what does the new law do, and what are we going to talk through? So firstly, it updates some existing consumer laws, introduces some new blacklisted practices, including fake reviews. There are some new provisions around drip pricing, subscriptions, and lastly, and probably the sort of key headline change, is around enforcement. So firstly, what's changed in terms of our existing consumer laws? Well, the Consumer Protection from Unfair Trading Regulations, the CPRs, was the UK legislation that implemented the EU Unfair Commercial Practices Directive. So what the new act does is repeal that legislation and restate it in this new act. So it's more or less a copy and paste, although there are a few tweaks, which we won't run through, but taken together effectively enhance the consumer protection position. But one of the interesting changes to these sorts of little tweaks relates to drip pricing. So Drip pricing is where only part of an item's price is shown early on in a consumer journey, so sort of headline price. But towards the end of the buying process, additional add-ons suddenly appear. So in this example we've got on the screen, somebody's gone to buy some flowers, and it's only right at the end of the process that you see these additional add-ons like care and handling. So what the new Act does is it prohibits drip pricing by amending the definition of material information, which is that information that you need to think about when assessing whether there's been a misleading act or omission. So you can't any longer present a headline price, so that sort of initial starting price, unless you incorporate any fixed mandatory fees. So those are any add-ons that are going to apply to everybody buying your product or service. You also need to disclose the existence of any variable mandatory fees. So that might be add-ons that might not be applicable to every single buyer, but you need to disclose what they are and how they are calculated. So moving on to some of the new banned practices. So fake reviews have been introduced as a banned practice. So submitting or commissioning a person to write a fake review or otherwise concealing that a review's been incentivized is not permitted. Can no longer publish reviews in a misleading way, and that includes removing or failing to publish negative reviews, or perhaps giving more prominence to positive reviews. Also need to ensure you take reasonable and proportionate steps to prevent the publication of fake reviews or otherwise disclosing incentivized reviews. So these banned practices are quite similar to some of the changes I know have happened in Europe under the Omnibus Directive. One thing I will mention is I believe under the Omnibus Directive, traders have to provide some information, and they have to say whether and how a review that comes from a consumer, whether and how a trader ensures that reviews from consumers actually come from consumers who purchased the product being reviewed. So I'll note that actually under UK law, we haven't included that requirement. So most banned practices constitute criminal offences. Worth noting, these fake review prohibitions actually will only attract civil liability. So the key risks here are fines, which I'll come back to, but could be fairly eye-wateringly large. Before we move away from banned practices, it's just finally worth noting that the UK Secretary of State does have the power to introduce new banned practices, even once the legislation is forced. So watch this space to see if there are any further additions. The UK consumer regulator, the CMA, has been very interested in dark patterns. So it wouldn't be surprising if we saw a few more banned practices relating to these sorts of practices. So let's move on to subscriptions. So subscriptions make up a very large part of the new legislation. Lots of new rules and requirements, but given the length, we'll just run through these at a fairly high level. So the first new requirements are around information that needs to be provided to consumers. So traders now have to provide these two separate buckets of information, one being this key pre-contract information. So this information needs to be given all together in writing and separately from any additional information, so separately to that full pre-contract information. And the key information is really the essential ingredients of the subscription. So things like the amount and frequency of payments, any charges after a trial period, total amounts payable, how auto renewal works, termination, notice periods, cancellation and cooling off, and reminder notices. So in addition to that bucket of information, traders also still have to provide this fuller pre-contract information. And this fuller pre-contract information largely reflects the requirements that are already there under UK law currently, so under the consumer contracts regulations. So that information, as currently is required, needs to be made available before and after contract is formed and on a durable medium. The new rules around subscriptions do also include quite comprehensive requirements around reminder notices and cancellation. So regarding reminder notices, these new requirements are supposedly meant to deal with zombie subscriptions. So these are subscriptions that just go on and on and on, keep auto-renewing and are very easy to forget about. So reminder notices are supposedly going to help address those sorts of subscriptions. So traders will need to send reminder notices. It needs to detail amount of any renewal payments, when payable, how that price is different from the last payment, when the next payment will be, and how you can end the subscription before that renewal payment comes into effect. So reminders for monthly subscriptions need to be given every 6 months, whereas for annual subscriptions, you need to give 2 reminders towards the end of the subscription term. When the legislation was in draft form, there was some very detailed requirements about exactly when you have to give these notices, but the final legislation that's been removed, so there is some discretion about when a trader can give these notices, so consideration needs to be given to what's fair in that context. In terms of cancellation, consumers need to have their 14-day cooling off period, as well as the ability to exit a subscription in a straightforward way. So the cooling off period applies at the start of a subscription, after any free trial, and after some renewals in some cases. What's very interesting is the legislation doesn't actually address what happens if a consumer's been using a subscription during this 14-day period. But the government has said it will issue secondary legislation on this, and it suggested they may introduce a sort of use it or lose it rule. So I think we can expect if a consumer has used a subscription in that period, they probably won't be entitled to a full refund. And lastly, so the really headline grabbing element of the new law is the enforcement regime. So the CMA, the UK's consumer regulator, is getting some fairly strong new powers, including the ability to directly fine. So currently, the regulator has to go through the courts. It's quite a protracted process, and as a result, not many fines are issued, and not many cases are taken to court. So the CMA, under the new Act, will have its own enforcement powers. And whilst it can fine, the courts will continue to have the right to also impose fines. And these fines are pretty eye-watering. So it's fines of up to the higher of 2 caps, so either £300,000 or 10% of a business's global annual turnover. So very high fines. And there are also some additional fines for traders that don't cooperate with the regulator, or perhaps provide misleading information or don't comply with any undertakings they've given. So in a nutshell, the new enforcement regime will really materially increase the risks of non-compliance with UK consumer laws. So we're seeing a lot of businesses get their house in order as a result. Thank you very much. I will hand over now to Conor.
Yes, thank you, Fleur. And Conor, we will end up our today's webinar with your presentation.
Thanks, Dusan. So I'm just going to cover one topic this afternoon, or depending on where you're coming from, but similar to topics we mentioned earlier, I'm just going to speak about influencer advertising and marketing and some updates that have happened in Ireland over the past number of months. We're going to look at 3 different areas where there has been increased activity in that area. So the Advertising Standards Authority of Ireland have issued their own new guidance document for influencers. I suppose it's a topic that's come up for them a number of times in the past few years since the idea of influencers grew. Originally, they kind of came up with the idea that they would just indicate, look, you know, our normal rules apply to social media and their advertisements, and they're just covered by the code. The same with the Consumer Protection Act, the laws apply to these ads the same way. And then the idea of influencers came into it as well, and there was a kind of a grey area where no one knew what would happen with it. So the ASA has issued in the past guidance, and they've taken a kind of a soft touch approach with influencers originally, but over the last few months, probably down to industry research and kind of public research in terms of what people understand from influencer advertising, there's been an increased focus from the ASA, but also from what's called the Competition and Consumer Protection Commission, which is the public authority for consumer protection enforcement. And probably from the influencer's perspective, the most, I suppose, scariest point that the revenue commissioners have started looking at them now as well, and decided that maybe they should be looking at the tax issues that come up with influencer posting as well. So just looking at the Advertising Standards Authority first, they issued a guidance document at the end of 2023, which is quite detailed, and the idea behind it, I suppose, was that they would see themselves as trying to help the influencers and the brands to come up with proper posting, and their kind of headline point on it was that they want instant recognition. So they want the viewer or the browser or whatever it is to be able to see commercial content for what it is. It isn't always easy, I suppose. If you think about social media, people are going through stories or posts and might look at something for 5 seconds and move on. So they said, look, you know, you could fall in trouble with the Advertising Standards Authority under our code and get all the negative publicity that goes with that. The Consumer or the Competition and Consumer Protection Commission has the right to bring court proceedings or enforcement, so that's obviously another threat that hangs there. And probably, again, most heavily for the influencers, as I said, you know, at the end of the day with this, you could lose followers or lose the income from the brands if you're not doing it properly. So here's how to do it properly. So the first thing they kind of looked at is the idea of who does this cover? Like, what is an influencer? What are they saying it is? So they're kind of saying it's, you know, the content creators, online personalities, online streamers, bloggers, celebrities, sports people, or any other media personalities. And interestingly, they've also said it can be a human, virtual, or some kind of like animal persona as well. So it's not just individuals, it can be accounts that are for commercial kind of cartoons or whatever as well. All of those are going to be covered by what they term influencers. Additionally, then they've said, look, you know, what do you need to disclose here? Like, what is the idea that's there? So where do you need to look at? They're saying, look, if you're getting a benefit, then a benefit could mean a monetary payment, it could be commission, it could be proceeds out of sale, it could be a discount that you're getting from the brand, it could be getting a free trip, whatever that may be, the gifts. All of those things are seen as kind of posted content that need to be disclosed. The type of content they looked at in the guidance as well then, so they set that out for influencers and brands to see exactly what that is. And again, they're saying, look, it's not just ads as such, it's advertising your own brand. It's if you're doing a review and getting a benefit, if you're getting sponsorship, if you're a brand ambassador, if you're posting discount codes or kind of affiliate links or anything like that, if you are putting a page on a retailer website, if you have kind of promotional content or competitions, or even if you're just sharing content from a brand, but you're getting some kind of commercial benefit for that, then all of that is content that you need to disclose. If you're reposting, if you are an affiliate of a brand, anything like that, you have to cover all of those areas. And they focus then on visibility as well. So they want all of this to be clearly visible to people. They say it's not exhaustive, so, you know, they can move this on and look at it. If there's something that's not covered in those kind of specific lists, then they can go back and say, okay, well, look, it isn't an exhaustive list, so we think this is commercial content and you should have disclosed it. The other point then that they, again, kind of, I suppose, helpfully from the perspective of the influencers and the brands who normally reach these agreements with influencers, they've also given very clear guidance on what they expect to see in the content now. So instead of just having previously, we just had a kind of a vague guidance saying, you know, guys, you really should make this clear. Now they've said, look, this is what you need to do. So they said, look, it needs to be, you need to think about it and you need to say, right, is this instantly recognizable? Is it clear? Is it prominent? And am I being honest with the people who are looking at this? they then moved on and said, okay, we're going to create a distinctive idea of what has to be in the posting. So there's a distinction now between what they call primary labels and secondary labels. You have to have a primary label in the content. And primary label is one of the two options that are there, so, or three options rather. So they have hashtag ad, hashtag gifted, or if the specific platform has a kind of a provided label that you can use, like paid partnership with whatever it is, then you can use that. But they're the only three options, and one of those three has to be on the content in order for it to pass that test. They have also then said, look, there are also secondary labels which you can use to allow for, you know, a bit more clarity on it, and they're encouraging people to do that. So they have hashtag collaboration, hashtag brand ambassador, hashtag sponsored, hashtag affiliate. They have PR stay, PR invite, brand investor, commercial relationship, things like that. But they're all seen as secondary. Those hashtags alone won't be sufficient to pass the test. So in order to get through that first test, influencers will now need to have one of those primary labels, hashtag ad, hashtag gifted, or platform, you know, whatever the platform provided label is on their content. And just to give you an idea of the focus from the Advertising Standards Authority that's on this now, the screen there, the page that I've pulled up is a screenshot of the ASI website. If you go to make a complaint, just a general complaint, if you just take on the option on their website to say, I want to make a complaint, this is the screen that will greet you. So you can see there, social media influencer reporting is the first option that's on it. And, you know, a formal complaint is the third one that's there. So you can see the focus that they're putting on that now, that people going in, it's put up there as an immediate option. The ASA have said that they aren't going to, you know, go really heavily on influencers at the start with this. They would like to work with them. They want people to understand these things. And I think initially at the moment, if you do go down that route of clicking on the link there to social media influencer reporting, it will be seen as a kind of a contact from the ASA to the influencer to say, look, this is something that you need to focus on and maybe correct it that way. The other point, moving off the ASA, the guidance that they did in cooperation with the Competition and Consumer Protection Committee. So it was a joint effort. As you can see there, the CCPC is the statutory body for enforcing compliance with consumer protection law in Ireland. They've carried out research on consumer protection generally, but also with specifics in influencer marketing. And as a result of that, they got involved in the guidelines with the ASA. They were also involved in a kind of a European review on influencer posting. So they looked at influencers. I had the figure somewhere for how many ads they looked at, but they saw 97% of them were posting commercial content. 38% of those postings were using incorrect wording. The disclosures weren't correct. And interestingly, the percentage of influencers posting from Ireland was far higher than the Irish population as a general percentage in Europe. So it's a busy industry here. They found, I think they wrote to 26 separate people in April of this year, giving them a specific warning about their content to indicate it's non-compliant with the Consumer Protection Act, it's non-compliant with the ASA guidelines, and that something would need to change with it. Lastly, just the revenue commissioners have also released some information this year, and they've said I suppose it's not really an advertising point for the influencers, but perhaps it's something that they're more scared of, because the revenue have said, look, we're now looking at compliance with tax law and influencers and whether you're declaring everything that you should be. So they wrote to 124 different influencers on their compliance with tax, whether they're using the correct labeling, but that also means that then they move on to the correct, I suppose, tax law with it. Just briefly on what's coming down the line, because it is a kind of an organic topic. I know that the ASA here, and I think some of the other European bodies, are looking at the idea of certification for influencers, so that you can apply I think it may be in France already. It's certainly coming in Ireland that you can apply to the ASA here, you know, follow a certain route and then get a certificate to say that your influencer postings are compliant with Irish law, the ASA, and the idea being that brands would then only work with influencers who are certified. And the second part, I think the CCPC have said that they're also going to look at the issue of the platforms themselves, the social media platforms, and what they can do to force the platforms to get people posting on them to comply with advertising law in general as well. I know it's a topic that goes far beyond advertising law, but the CCPC have focused it on the influencer side as well, so that the platforms would have to help them appropriately label what they're posting. And the last point on it, just the ASA gave that little helpful phrase for all the influencers to bear in mind, say if in doubt, label it. And that's everything from an Irish perspective. So I'll pass it back to you, Dusan. Thank you.
And thank you, Conor, for your Irish perspective. Thank you, Fleur, Ignacio, and Baran, for your presentations. Dear attendees, thank you for your participation and staying with us for this webinar. Before we leave, let me point out, or let me say a few words about the resources so you can stay in touch with the advertising content until, for example, our next webinar. You can check important things on our GALA website at galalaw.com, or maybe more convenient option for you is to subscribe for the GALA blog, which you can find on the GALA website. If you subscribe, you will get notifications when the articles are published, and on a monthly basis, you will receive a newsletter summarizing all the articles that have been published for the last week. So thank you again to all of you speaking and participating on the webinar, and see you sometimes in the future on another occasion. Thank you and goodbye.